So Diddy's going to prison, and there's a lot of confusion going on in new information from the David investigation. Is he a person of interest or not? And there are some updates in the Karen Reed case. The judge issued a ruling in the civil wrongful death case where Karen Reed had filed a motion to dismiss, and that grand juror who was leaking information that we learned a lot about on live stream, well, they've also been sentenced. So we have quite a lot to talk about today. We just need to get into it. So let's go. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. So for those of you who are like, wait, I thought Diddy had been sentenced. Nope. Just happened at the end of last week. Remember, federal sentences take quite a while. And I think the last time we had really done an update on Diddy, his lawyers, after he was acquitted of some of the most substantial charges he was facing and then convicted of some of the charges that carry less significant sentences, his attorneys had argued that that was a change of circumstance and he should be allowed out of custody pending his sentencing. Remember, federal sentencing takes a minute. The pre-sentencing investigation report and all the rest of it takes some time. Plus, there's extensive motion work, which the parties did here. The federal government was asking for 135 months in prison, over 11 years. And Diddy's attorneys were asking for 14 months in prison. Emily, how long has Diddy been in since he was arrested? 13 months. He's been in 13 months. So Diddy's attorneys were essentially asking for a time-served sentence. If he had been sentenced to that, then it would have given him a pretty quick turnaround to being out of custody. The government disagreed with that. The government also asked for the maximum potential fine in this case of $500,000. And the court picked something in between. We also saw sentencing memorandum submissions from Cassie and other victims, and the court actually noted the victims' bravery in coming to testify when passing the sentence on Sean Combs. Ultimately, the court sentenced Combs to just over 4 years in custody. But of course, it is federal, so it's 50 months. Let's take a look at that real quick. So on October 3rd, 2025, it was a full day of sentencing, and the court sentenced him to over 4 years. As I said, 50 months. The federal system operates in months. It is always confusing to me to convert it. I know it should be simple at this point. It just isn't. But also imposed the maximum fine of $500,000. The court said these were serious offenses that irreparably harmed 2 women. The conduct occurred for over a decade. You had the power and resources to keep it going. The court also referred to Holmes as a self-made artist and businessman and a devoted father who has uplifted communities and businesses and donated his time and money in commendable conduct. He praised Combs for getting sober while in custody, in part to address his erratic and violent behavior. But the judge also said that Combs, quote, abused the power and control he had over the women in his life. Quote, you used that abuse to get your way, the judge said, citing massive evidence of Combs's, and this was the court's word, savage conduct that was presented at trial. Quote, this was subjugation, and it drove Miss Ventura and Jane to thoughts of ending their lives. The judge noted that trial evidence showed Combs continued to break the law into 2024, beating and taunting Jane even after he knew he was being investigated, and said for that reason, the court must protect the public from further law breaking. The judge also thanked Ventura, Jane, and other brave survivors who spoke out against Combs. Quote, we heard you, the judge said. I am proud of you for coming to the court to tell the world what really happened. With Combs's attorneys asking for time served and the prosecution asking up to 11 years and Combs facing a maximum of 20, the court went with 4. He's not just getting out of custody, and he was given the maximum potential fine. The government did not ask for restitution in this case, and I think that's because restitution has already been accommodated in the case of Cassie through civil settlement. I do not know as specifically as to Jane, but the government was not asking specifically for victim restitution. So Sean Combs will be transported from his local custody housing to federal prison to serve the rest of his sentence. We'll see if that gets reduced by programs he participates in, because there is some reduction, but it's not going to be much of a reduction. So though he has just about a year time served, we will see him in prison for the next several years. So less time than some were hoping for, more time than his attorneys were hoping for, and really acknowledging that the court heard the victims in this case, and that even though there were counts that were found to be not guilty by the jury, the court did not take the behavior in this case lightly. But he had been facing life in prison. So to go from life in prison to facing a 20-year maximum is a very big change in circumstance when you look at federal sentencing. So Sean Combs is going to prison. I suspect that he and his attorneys thought he would not face prison, but after spending a year in local custody, he will be going to federal prison. And for those of you that are interested, he also wrote a letter on his own behalf. The court noted it in court, but also said, you are a dangerous individual. You need more time in custody. And with that, it is time to talk about whether or not we will see singer David in custody or not. I continue to see really misleading headlines in the investigation into the death of Celeste Rivas, who has been connected to singer David, spelled D4VD, because her remains were found in the front trunk of his Tesla. More information keeps coming out about this case, and the way that people are interpreting that information is just absolutely wild to me. So I think we're going to have to do a podcast segment almost every week of, hey, that's not what that means. So for today's episode of, hey, that's not what that means, let's talk about some of the new information that has come out. What we don't know still is the cause of death and manner of death of Celeste Rivas. Because we do not know that, I am not surprised that law enforcement is not going to make any further or declarative statements, because if Celeste Rivas's death was not a homicide, if it was accidental in some way, then the investigation is into how she ended up in the front trunk of the Tesla, why she ended up there, who did that, and what are the appropriate charges. But that's not a homicide case. That becomes a different type of case. So not knowing the cause and manner of death is significant to the investigation, and that is going to take time. So with the headlines out there saying that he is not a suspect, well, no one's really a suspect yet until there is a crime that occurred. This is still a death investigation. And what crime occurred and what crime didn't occur is something that will still be investigated. So no one is a suspect at this point until they have a cause and manner of death. That doesn't mean that David won't be a suspect down the road. It also doesn't mean that he will. But of course, we've also seen news that he recently hired a criminal defense attorney. And you can imagine the directions that the internet went with that. And taking a look real quick at reporting by Fox 11 Los Angeles, David hires Hollywood top criminal defense attorney amid Celeste Rivas death investigation. This is from October 2nd, that the singer has hired renowned criminal defense lawyer Blair Burke amid the intensifying probe into the death of 15-year-old Celeste Rivas. Look, here's the thing. Hiring a criminal defense attorney when human remains were found in a car registered to you that had been parked outside the house where you were living makes a whole lot of sense. You absolutely need to, at that point, start having a conversation with a criminal defense attorney. Also, I don't know how the media got this information. Did the defense attorney leak this information? Did David hire this defense attorney? Was this defense attorney hired by the label, his manager, those around him, his parents? I don't know. We don't know. But why does the media know? Somebody wanted the media to know, because otherwise the lawyer wouldn't share this information. Was a crime committed is the next sub-headline from this article, and it says, what we know. The hiring of Burke, known for representing celebrities in DUIs and other minor legal issues, comes on the heel of LAPD's statement that criminal liability in the case may not extend beyond the concealment of a body. There's no cause and manner of death yet, so what is known is limited. And then they go on to list past celebrity clients of Burke, including Lindsay Lohan, Kanye West, Mel Gibson, Harvey Weinstein, Britney Spears, and Reese Witherspoon, and then talking about other criminal cases Blair Burke has been involved in. Look, anyone in this situation should be talking to a criminal defense attorney. I'm curious why this information was released to the public and what they wanted the public to think. Some people are going to think, well, if you hire an attorney, you're for sure guilty. I don't agree with that. You should 100% talk to a lawyer. And some might say rich people need to hire attorneys. Yeah, they do. Defense attorneys represent a wide variety of interests and can keep you appraised of what's going on, but also can help you protect your interest. And in some of the criminal cases we've seen, a lot of the questions that come up initially are, why did their lawyer let them talk to law enforcement like that? So if nothing else, having an attorney to run thoughts, concerns, next moves, having an attorney to run those things by makes a lot of sense. So anyone in this situation should be talking to a criminal defense attorney. I'm not surprised that law enforcement has not said that this is technically a homicide investigation until they have an idea of cause of death, because there are numerous accidental causes of death that would take this into that category of accident. And then you're looking at concealment of a body. We just don't know. And we might not know for a little bit. This reporting is coming to us from Rolling Stone, where they indicate some new information with regard to how long the Tesla had been parked in the residential neighborhood. Rolling Stone is reporting that the Tesla registered to David had been parked for several weeks before it was finally towed. So it gives us a little bit more of a timeline and a potential estimate of how long we might have seen decomposition happening. This is going to slow down the coroner's department. And so when you're looking at what the medical examiners are working with, you are looking at a car that had not moved for several weeks before it was towed. They report that sources in the neighborhood in Hollywood Hills say that the car was parked and did not move for weeks. They also cite 3 parking citations before it was towed away on September 5th, with remains being discovered on September 8th and then identified later. They also said that the vehicle had been moving somewhat sporadically prior to it being parked for weeks. Rolling Stone goes on to say that the vehicle had been parked at the location from which it was towed for several weeks, and that Ms. Rivas Hernandez may have been deceased for several weeks before the discovery. That statement comes from LAPD. They also say that robbery homicide has been diligently investigating the case, but are waiting for an official ruling on the cause of death. Though many online have speculated the teen must have been a victim of homicide considering how she was found, the medical examiner has yet to rule out the possibility that she suffered an accidental death. And then they go on to say in their statement that the LA County medical examiner has not yet determined the cause and manner of death. As such, it remains unclear whether there is any criminal culpability beyond the concealment of her body. They go on to say RHD, which is robbery homicide, is thoroughly examining every aspect of the case to uncover the truth and seek justice for Celeste Rivas Hernandez and her family. It's really not much more than that. Law enforcement is going to wait until there is an official cause and manner of death before moving any further with that. That does not surprise me. But the headlines I have seen saying that he's not a suspect and what have you aren't technically accurate, because it leaves the impression that he's somehow been ruled out, which is not the case. They are not ruling people out, and they are not ruling people all the way in until they know more. And that is just going to take some time. So as it goes in the death investigation of Celeste Rivas, we are going to have to wait until we have an official ruling and determination from the coroner. And we have seen coroners take 90 days, if not more, to make those determinations, which is why when the initial death certificate was released, the cause and manner of death were indicated as deferred. They have not made that determination yet. So Don't be dissuaded by the headlines that may be misleading. We just have to wait. More will be known. It's just not going to be known now. And I know that that's frustrating, but RHD is investigating. We will know more when the coroner makes a decision, and we will talk about it more when that decision happens. And speaking of decisions that we were waiting for, the court has ruled in the Karen Reed motion to dismiss in the civil case. Thank you to today's sponsor, Honeylove. Look, I want it to be fall, you want it to be fall, and it's all I am ready for. But I'm not ready for uncomfortable sweater weather. I am ready for the underpinnings that make sure that it is a completely smooth experience. Are you? Honeylove has you covered, from the best bras on the market to shapewear that works with you, not against you, so you don't feel like you are spending your day fighting with your underpinnings. And if you don't want to spend the night fighting how warm and or cold it may be, do not sleep on Honeylove's sleepwear. First of all, it is cooling, and the pieces are lingerie inspired, so you can feel a little sassy while being comfy. So if you are ready to get your sweater weather going with some spicy reeds and some pumpkin spice, and you still want to look snatched, it's time to treat yourself to the most comfortable shapewear on earth and save 20% off at honeylove.com/Lawnerd. Use our exclusive link for 20% off at honeylove.com/Lawnerd. And yes, that is site-wide. And after the purchase, if they ask where you heard about them, let them know the Emily Show sent you. It's time to experience the new standard in shapewear with Honeylove. Let's get back to today's episode. So, heading into Plymouth, Massachusetts, to the ruling in the Karen Reed motion to dismiss. You might have watched the motion to dismiss with me live, the argument on it. And if not, I will link that down below this episode if you want to go check that out on the live channel and see the arguments that the attorneys made. I think the most important thing to remember in a motion to dismiss is this is a motion based on the four corners of the complaint. It is not a finding of fact. It is, are the words that you're saying, if true, enough to make a cause of action happen? It does not mean that the court is weighing the veracity of the things that are said. The court is weighing, if these things are true, then is there a cause of action that can go forward here? Or does the law not allow this cause of action? Which is why most motions to dismiss are denied, because lawyers know how to plead complaints. And if the facts are there, now, if the facts are in dispute, the jury is going to have to determine them, which is where you get jury trials like we just watched live in the Cardi B civil case. Many of you asked in the Cardi B civil case, how did this not get just yeeted out of court before? Well, there was a genuine factual dispute between Cardi B and the security guard who sued her. The security guard said, she scratched my face. Cardi B said, no, I didn't. That is a factual dispute that needs to go to a jury. So even if Cardi B had filed a motion to dismiss saying, I didn't scratch her in the face, the court says, well, on a motion to dismiss, if everything in this complaint is true, meaning that you did scratch her in the face, then you've successfully pled a cause of action. And the factual dispute needs to go to a jury. We've also talked about this in the TikTok psychic defamation case, where we talked about the liability finding made at motion for summary judgment. Now at a motion for summary judgment, the court does start to weigh the evidence. And where there is no genuine factual dispute, the court looks at the evidence and says, there's no dispute over the evidence. Is there a cause of action? And is someone liable? And in that case, the court said, there's no dispute as to the facts. That shit's defamation. I mean, I paraphrase. The federal judge didn't say it that way, but I did. So with that, you now can see when the court is weighing the evidence, they're deciding down the road if there's a factual dispute. And if there is a factual dispute, that is what juries solve. Juries determine the facts. So all of that said, the court's ruling here is, did you say enough words that if taken as true, survive this beyond the point of a motion to dismiss? And for the most part, the court said, yes, this is pled, so it survives a motion to dismiss. But one cause of action was dismissed. So let's take a look at that real quick. Again, not a factual finding. The court is not saying this is true. The court is saying, if this is true, then you have civil causes of action. And oftentimes you will see the ability to plead again to try to fix it. I don't know if that will be done here. There haven't been any additional filings since this ruling on October 3rd. And we are not going to deep dive the entire ruling. We're going to look at the main decision points of the court's ruling. If you want a full deep dive into the civil case, into what is being alleged and who's alleging it, I'll link those down below. I've mostly been covering that on live stream, but this is in regards to the civil wrongful death suit brought by John O'Keefe's family members. The court says this matter arises out of the January 29th, 2022 death of John O'Keefe. Defendant and moving party Karen Reed was previously charged with several crimes in connection to his death. During the pendency of the criminal case, plaintiffs Margaret O'Keefe, John O'Keefe's mother, John O'Keefe II, John O'Keefe's father, Paul O'Keefe, his brother and personal representative of the estate, and Kaylee Furbush, the niece, filed a civil lawsuit asserting claims against Reed for wrongful death, negligent and or reckless infliction of emotional distress. Those are counts 10, 11, and 12. And negligent and or intentional infliction of emotional distress, count 13. They also asserted claims for wrongful death and negligent infliction of emotional distress against CNC Hospitality, DBA CF McCarthy's, and GNS Hospitality, DBA CF McCarthy's, and the Waterfall Bar and Grill. Reed filed a motion to dismiss all emotional distress claims against her. CF McCarthy's and the Waterfall joined in the motion to dismiss, seeking to dismiss the emotional distress claims against them. For the reasons discussed, the defendant's motions are allowed, which means dismissed. As to Kaylee's claim for negligent infliction of emotional distress, the defendant's motions are denied in all other respects. So the only cause of action that was dismissed was the niece's claim for negligent infliction of emotional distress. That's what we are going to take a look at. The others, the court said, yes, if these facts are true, which is the standard the court has to apply, then there is enough here for the case to move forward. We are just at the beginning of quite a lot of litigation. So looking just at the claims asserted by the niece, the defendants argue that the complaint does not assert sufficient facts that Kaylee suffered emotional distress, that it does not describe which conduct applies to which claim. As discussed above, the claim for negligent infliction of emotional distress must be dismissed for failure to state a viable claim. However, consistent with Margaret, John, and Paul's claims, Kaylee was also plausibly distressed by the public and pervasive nature of Reed's alleged false narrative. The alleged facts surrounding Kaylee's interactions with Reed in the early morning hours of January 29, 2022 can also be plausibly characterized as extreme and outrageous. Such determination supports the claim for reckless infliction of emotional distress. Kaylee is the only plaintiff who asserted a claim for intentional infliction of emotional distress. A claim for intentional infliction of emotional distress requires sufficient averments that Reed, quote, intended to inflict emotional distress, or that she knew or should have known that emotional distress was the likely result of her conduct. With reference to the specific allegations of the complaint, Reed's motion states that defendants questioning what happened during a phone call with third parties, even in the niece's presence, is also not actionable conduct. This does not convey the full scope of what occurred during the early morning hours of January 29, 2022, in the manner alleged in the complaint. Instead, the complaint plausibly pleads that Reed made multiple distressing calls about John O'Keefe's physical condition, and the order refers to him as JJ. The plaintiffs have all referred to John O'Keefe as JJ, namely being struck by Reed's vehicle or by a snowplow. Moreover, Reed made these statements upon waking Kaylee up at 4:30 a.m., which plausibly contributed to the distressing nature of the interaction. Even if this court were to accept Reed's position that she was merely engaging in telephonic conversations, and then it quotes case law saying, conduct otherwise reasonable may become tortious when directed at an individual known to be particularly susceptible to infliction of emotional distress. This is the court's writing verbatim. At time of this interaction, it can be inferred that Reed knew Kaylee was a vulnerable minor who previously lost both parents and lived with John O'Keefe as her surrogate parent. Given such status, Kaylee would be particularly vulnerable to distress caused by an additional loss of a parental figure. Thus, Based on Kaylee's vulnerable susceptibility, Reed, at a minimum, knew or should have known that her conduct would cause Kaylee to suffer emotional distress. This plausibly supports a claim for intentional infliction of emotional distress. The motion to dismiss that is denied. Whereas defendants' motions are allowed as to the negligent infliction of emotional distress claims by Kaylee and denied as to their claims for reckless or intentional infliction, defendants' motions are denied. So looking now at the claim that as to the niece was thrown out. So when the court is saying that the motion to dismiss is allowed, which is what we're going to look at now, the motion to dismiss being allowed is throwing out that cause of action. The motion to dismiss being denied means those causes of action go forward. So continuing forward on the cause of actions for the negligent infliction of emotional distress, the court says the defendants argue that none of the plaintiffs have actionable claims for NIED because their alleged distress did not occur contemporaneously with the accident giving rise to John O'Keefe's death. This argument is inconsistent with established Massachusetts case law, and the court cites the law. We saw them argue this quite a lot when we heard the oral arguments on these motions. Arguments about whether somebody is on the scene when something happens, if they come upon it later, how much later, in this case, the accident counts as negligent infliction of emotional distress. Litigating whether or not there was an accident comes later because as pled, there is pleading that there's an accident. So there was much argument about family members going to the hospital, family members being on the scene when they were arguing this aspect of the motions. The court, citing Supreme Judicial Court rulings, says that the Supreme Judicial Court has held that allegations concerning a parent who sustained substantial physical harm as a result of severe mental distress over some peril or harm to his minor child caused by the defendant's negligence state a claim for which relief might be granted, where the parent either witnesses the accident or soon comes on the scene when the child was still there. So they are looking at different case law to talk about whether or not the case law supports Karen Reed's argument that the distress suffered by John O'Keefe's family members was too distant in time, e.g. not contemporaneous enough. The court summarizes that saying, thus, a family member is entitled to emotional distress damages when they either witness the decedent's actual injury or, quote, come upon the injured kin promptly after the injury. The plaintiffs allege that Reed discovered O'Keefe buried in the snow at approximately 6:03 a.m. on January 29, 2022, and he was subsequently pronounced dead at a hospital at 7:50 a.m. that day. Margaret, John, and Paul each aver that they, quote, learned of John O'Keefe's admission to the hospital immediately and came upon John O'Keefe's body at the hospital shortly thereafter. Complaint paragraphs, and then they list all of the paragraphs where that is alleged. The court says against this backdrop, the complaint alleges sufficient facts that John O'Keefe's parents and brother arrived promptly at the hospital upon learning of John O'Keefe's death and thus have actionable claims for negligent infliction of emotional distress. They go on to then talk about Kaylee, who is differently situated because she did not go to the hospital. Kaylee, the niece's NIED distress claim stands on different footing, the court says. She alleges that she learned of John O'Keefe's death or injury when defendant Karen Reed woke her up at 4:30 a.m. on January 29, 2022, complaint paragraph 147. Furthermore, the niece alleges that she, quote, heard defendant Reed say, John never came home, maybe I did something, maybe a snowplow hit him, maybe I had hit him, maybe I hit him. We were in an argument, maybe he got hit by a snowplow, complaint paragraph 150. Lastly, the niece states that as a result of Reed's conversation in her presence, she perceived the injuries caused to her guardian and perceived the injury-producing event. Taken together, the complaint does not allege that the niece learned of John O'Keefe's death or injury at 4:30 a.m., but instead learned that he was maybe injured at that time. There are no averments regarding when and the circumstances under which she first observed the deceased John O'Keefe. Her averments concern her perceptions of his injuries rather than actual observations. The case law cited by the parties addresses scenarios where a family member has observed another family member actually being injured or otherwise suffering shock after promptly encountering the injured family member. The niece, Kaylee, cannot make this showing. In making this assessment, the court acknowledges the following case law cited by the plaintiff's opposition, and then they list out the case law. The court goes on to say, neither of these cases nor any other cases provided by the parties creates authority to find negligent infliction of emotional distress for family members who learn of a death beyond the prompt timeframe. Thus, the case cited language about when the injury, quote, entered into the consciousness of the claimant does not support Kaylee's claim for negligent infliction of emotional distress. Therefore, as to Margaret, John, and Paul, the motion is denied with regard to the NIED claim, but with regard to Kaylee, the motion to dismiss is allowed for the NIED claim. The court goes on to say in their final order that wherefore the defendant's motions are allowed as to the NIED claim asserted by the niece Kaylee and denied as to all other claims. The defendant's motions are denied in all other respects. So this turns on specific facts and case law where you see the court saying the facts as alleged, if true, do not legally support a claim. So one of the claims was removed. We will see if it's refiled or not. It may not be. This doesn't answer the larger question of Karen Reed suing everybody. What about Karen Reed suing everybody? Well, that's going to be the next phase of litigation that we will see here because her lawyers are going to be filing motions, as they said in court when they were arguing this motion, regarding how they want to bring in not just government entities and law enforcement, but also the McCabe's and the Alberts. So there is quite a lot of litigation to go. This case is going to take substantial litigation. The court has been allowing cameras in the courtroom, so it is something that we can keep an eye on. I know when we were watching the first argument in this case together, there was a lot of frustration about the way that this case is situated through the eyes of plaintiffs, but the court is not making factual findings at this time. The plaintiffs are saying this is what we think it is. You may disagree after watching the Karen Reed trial, but the court has to take that position as true for these early stages of litigation. That will change as we go through these early stages of litigation. My only hope with regard to John O'Keefe's niece, because only one claim as to her remains, is that perhaps they will be able to settle the niece out of this entire claim and let that go. I worry that the plaintiffs will be hesitant to do that because, well, it looks bad. Waking up the niece and freaking out on her and worrying about John and causing the niece distress looks bad. So when they go to trial, I imagine that they want those facts in there at trial. But I would hope that they would be able to let the niece settle out and not go through another trial on this. But as to John O'Keefe's parents and brother choosing to fight this, they're going to choose what they're going to choose to do. I just hope that as to the niece, if this can settle as to her, to let her start to move on, if she can move on, that happens. That is my hope in this. Civil litigation is draining, is emotional, and is extensive. I think Karen Reed is probably mentally fortified to that at this point after going through 2 criminal trials, facing substantial prison consequences, that the civil case is maybe not going to be as emotionally draining on her. But as to the niece, I just hope that maybe that part of the civil case will get excised out and the adults can go to court and do what they're going to do. But we will see. Thank you to our sponsor, OneSkin. You've heard me talk about OneSkin's skincare and their OS1 proprietary peptide that they use in a number of different products, including the product that we're talking about today, which is the hair serum that goes on the scalp. So sometimes you might notice a little bit more hair in the shower or on your comb or hairbrush than you want to. Well, that's where OS1 Hair comes into play. OS1 Hair works by targeting cells in the hair follicles that contribute to shedding, thinning, and slower hair growth. OS1 hair can actually reactivate the hair growth cycle and promote thicker, fuller, denser hair. And who doesn't want that? I don't have time for extensions. I want my hair just better. You've heard me talk about OneSkin's skincare and their hair serum. And if you are ready to try the OS1 peptide for yourself, it is born from over 10 years of longevity research and is proven to target the cells that cause the visible signs of aging, so your scalp and your hair stay healthy as you age. Go to oneskin.co/hair and use code LAUNERD for 15% off your first order. That's code LAUNERD at oneskin.co/hair. And after your purchase, if they ask how you found them, let them know it was The Emily Show. Thank you to today's sponsor, Jones Road. You might have heard of makeup artist Bobbi Brown. Jones Road is the minimalist makeup brand brought to you by Bobbi Brown. One of my favorite products, the Miracle Balm, can be used on anything you want to use it on. I went with the Chic color palette because I enjoy the buildable cool tone shades, and what I appreciate is that it considers our skin as we age, so it doesn't settle into fine lines, pores, and the rest of it. So the shade at the end here, Happy Hour, has been an absolute gift to find a highlight that just illuminates without screaming at you. It doesn't surprise me that the Miracle Balm is their bestseller because it is skincare that's a hybrid with makeup. So you can use it as a tint, a blush, a bronzer, a highlighter, all the things. So if you're ready to try modern day makeup that is clean, multifunctional for that effortless look, for a limited time, Emily Show listeners are getting a free cool gloss on their first purchase when they use code LAUNERD. Head to jonesroadbeauty.com and use code LAUNERD. And at checkout, they'll ask how you heard about them. Let them know it's The Emily Show. Let's get back to today's episode. And before we're all the way done talking about Karen Read today, we do need to talk about that grand juror. Now, if you haven't been following along on the live channel, you might not know a ton about this case because we talked about it heavily on live. But here is the TLDR of that case. A woman who was serving as a part of a federal grand jury in Massachusetts. Remember, federal grand jurors sit on numerous cases. So she had sat on numerous cases and had revealed private, secret grand jury information to her former friend, who then shared that information with the internet. And the defense argued in the sentencing memorandums, she lost her job. She's been punished enough. And the government was like, let me tell you what. Not only did she not do this just once, but she worked regularly with the court system in her job as a social worker. She knew what she was doing. And in fact, she told the friend, this is illegal. Other grand jurors don't do this. And yet she continued to drop the tea, including sharing the names of grand jury witnesses, which can put them in substantial danger, that indictments had been returned, which ended up on the internet before those indictments were ever unsealed and individuals were arrested. The substance of witness testimony, you know, all the things that are supposed to be kept secret. So she was charged with one count of federal, criminal, felony, contempt of court. And the feds and the defense organized a deal, I think before this was even filed, where she would get 1 day time served and probation. Do you know what the court said?
Nope.
The court said nope. And this is the thing about federal sentencing. While the defense and the prosecution might agree to a sentence, the court might say, that's not what we're going to do. We're going to not do that. Remember when that happened to Alec Murdaugh, how mad he was when the court went above what the government recommended, which is rare. In federal sentencing, they normally undercut what the prosecution is asking for and go lower. That's not what happened here. The court rejected the agreed upon disposition, said no, and said, you know what? What we're going to do is a little bit more than that. Do not piss off the courts when it comes to being a member of a grand jury. Don't do that. This information is coming to us from WCVB, the Karen Read grand juror who leaked information sentenced to 2 years of supervised release. But wait, there's more. A former state employee who pled guilty to leaking information from the grand jury investigation into Karen Read. It wasn't just the Karen Read investigation, because there were leaks with regard to the CDL scandal in Massachusetts as well. Was sentenced Thursday to 2 years of supervised release, including 2 months of home detention, her attorney confirmed. So the 2 months of home detention and the 2 years of supervised release were more than what was originally asked for. Of course, the defense had argued that she had already lost her job and that more didn't need to happen. And the court said, no, you're going to be on house arrest. House arrest, though it might seem like, well, you're at home, for a contempt case is a heavy sanction. It's also an expensive sanction because when you're on home detention, you have to pay for home detention. And then she is going to be on 2 years of formal reporting probation, which is probably going to make it difficult to find new employment after losing employment due to this felony conviction. So there are times if you faff around with the courts, you are going to find out. So while they were asking for 1 day time served, the court said no. 2 months of house arrest. Pay for it, 2 months of house arrest. And if you're interested in how the sides argued and how much information they shared about what she had done, I'll link that live stream down below. And if you want to keep up with the other things we have going on, you're going to need the Lawnerd app at lawnerd.com so you don't miss a moment. We're going to be talking about some lawyers behaving badly this week, and then we have cases coming down the road that we need to check in on. So don't worry, we will get there. If there's a case that you are waiting to hear about, link it down below. Look, for all of you asking, Emily, Corey Richins, that is going to trial in February. We're going to get into some of the pretrial litigation soon. Don't worry. And I'm going to take a look at how long the Brian Walsh case is going to litigate and see what we may do there. So I have an open mind, but it really may well conflict with BravoCon, and we're going to have to figure that out. So lots of cases to come, lots of live court, and don't forget, we have more hearings coming up with Donna Adelson. She has not been sentenced yet, and I'm sure we're going to see an appeal, but the court just slapped down her motion for new trial with all of the receipts he could bring. And if you haven't seen that yet, don't miss that. The court had all of the things to say. With that, thank you for being here. Thank you for being a Lawnerd. I will see you in the next one. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Lawnerd.